The U.S. Supreme Court delivered an array of important decisions this week. They range from smartphones to presidential powers. One of the cases touches on an issue that most Americans feel very passionately about: abortion rights. In that case, the High Court struck down the Massachusetts law that banned protesters within 35 feet of an abortion clinic. Steven Schwinn will guide us through some of these critical decisions. Steven is an associate professor at the John Marshall Law School in Chicago, and he joins us from Chicago. Hi, Steven. It's good to see you. Thank you so much for being here with us.
Hi, Debbie. Thank you for having me.
So as we march through these, I think, first of all, I'm just going to ask you to give me a general summary of the ruling, and then we'll pick it apart a little bit as we go along. Okay, that sounds good?
Sure.
So let's start with this ruling about protesters, the ban against protesters outside of abortion clinics. What is the ruling? And then just go ahead and tell me what it means.
So the ruling is that a so-called buffer zone around an abortion clinic, which is a kind of free speech zone, or I should say anti-free speech zone around an abortion clinic, is unconstitutional. The way the Massachusetts law worked is that they had a 35-foot buffer zone around clinic entrances where people could not speak. And it was designed to protect people going into and out of the clinic to get an abortion.
So tell me, what does this offer a framework for more limited restrictions around clinic demonstrations?
Well, yes and no. One of the things that the court did, Debbie, is to kind of provide a roadmap for states that were interested in providing protection to women who are going into and out of clinics to get an abortion. And so while on the one hand the court struck this particular kind of buffer zone, it also reaffirmed a different kind of buffer zone, a kind of roving, floating buffer zone for women going into and out of the clinic, and also gave states ideas for other ways to protect women going into and out of a clinic.
And you're alluding to the next question that I was going to ask you. Does this then strike some sort of balance, between protecting those who are going into the clinic as well as allowing others who want to express their freedom of speech to do so?
I think it does, or at least I think that's what the Supreme Court would say that it was trying to do: balance the free speech interests of the anti-abortion protesters, or in this case, people that said that they were counseling women about alternatives to abortion in a kind of gentle way as they were going into the clinic, balancing those rights against the rights of the women to get an abortion.
All right, so let's move on. Anything else important to note about that ruling before we move on, Steven?
I don't think so. I think probably both sides may be overstating the opinion to some degree. We'll see what Massachusetts and other states do in the wake of the opinion. Okay,
so let's move on to the other big decision that made news, and this was actually a federal court of appeals decision, and that was to strike down the ban of gay marriage in Utah. So first of all, tell us then the summary of the ruling and what it means.
So this is a huge decision, Debbie. It's the first federal appeals court to overturn a state ban on same-sex marriage. One of the notable things that the court did is to recognize a fundamental right to marry that extends to same-sex couples. That's notable because what it means then is when a state interferes with a same-sex couple's right to marry, it's subject to a higher level of scrutiny in the courts.
So tell me a little bit about this one and how and under what circumstances, Stephen, do you think that the Supreme Court would weigh in on this issue?
Well, so I think it's inevitably headed to the Supreme Court, and it very well may be this 10th Circuit case that gets there. A number of lower federal courts have ruled on same-sex marriage. Many of them have struck state bans on same-sex marriage. I think this is something that inevitably is headed for the Supreme Court. But I think maybe more importantly, we've got a number of lower federal courts ruling on this, striking bans on same-sex marriage, a number of states taking action to recognize same-sex marriage. I think whatever the Supreme Court says, I think this country is inexorably headed toward recognizing same-sex marriage.
Yeah, and I know you said this, but I just want to underscore it again. What is really notable about this is that the court says that every individual has a right to marriage.
That's right. It's a very notable part of the decision that there's a fundamental right to marry, and it's a right to marry that extends even to same-sex couples.
Okay, let's turn our attention then to another Supreme Court decision, and this was to strike down the recess appointments that President Barack Obama made to the National Labor Relations Board. Explain this decision and how it sort of resonates through the politics of it.
Okay, so what was happening is that the minority in the Senate, the Republicans, were frustrating President Obama's ability to appoint people to boards like the NLRB by using the filibuster. And so what President Obama did was say, well, okay, if that's going to be the case, then what I'll do is go ahead and use the recess appointment authority to make those appointments. In reaction, what the Senate did was to enter into a series of what they call pro forma sessions, where they gavel themselves in the next instance, gavel themselves out of session, but at least theoretically can do business during that period, meaning that they're not in recess and that the president can't activate his recess appointment powers. What the ruling said yesterday was that the Senate is in session when the Senate says it's in session. And that was a pretty serious blow to the president's recess appointment authority. But on the other hand, the court in important ways opened up at least the potential for the use of the recess appointment authority in other kinds of ways. At the end of the day, for President Obama at least, I'm not sure it's going to matter that much, because with filibuster reform last fall, led by Harry Reid and the Senate Democrats, I don't think Republicans are able to obstruct presidential appointees the way that they used to, thus forcing President Obama to use the recess appointment power at all.
Yeah, that makes this point a little bit moot at the end of the day, I suppose. All right, Stephen, you've done a great job explaining this to us. Thank you so much. We do appreciate it. We'll see you again, hopefully very soon, to talk about some more Supreme Court decisions.
Indeed. Thanks for having me, Debbie.
Thanks.